biggest concern that we're addressing is the validity of the petition process. We have some legal concerns with that. We have requested that a third party take a look at it who is independent. They have come back and stated that they believe that the petition itself is invalid. Therefore, we are requesting to bring this forward to the court so that we can get a declaratory judgment so that we can move forward with confidence.
In order to hold an election, you have to have a mechanism in order to hold that election. Usually it's a statute. In this case, it would be a petition. If the petition is found to be invalid, then we couldn't have a lawful election because we would not have any authority in order to hold that election. So we need a third-party judicial determination that this is either a valid or an invalid petition. If it's determined it's an invalid petition, then the governing body could not move forward with an election. If it's determined it's a valid petition, then I'll go back to the governing body and they'll take the appropriate steps at that time.
The key here is that we need to proceed in a manner that we feel is legal and one that we can have confidence in. Because of the concerns with the validity of the petition, we don't believe that we can take any action other than clarify what the legality of the petition is. If we were to go forward with an election, we could very easily be sued later on, and the results of that election would be challenged.
In late August is the first time that we received a copy of the actual petition. When we examined the petition, we noticed some things that we thought were some issues. The statute cited was incorrect. Some of the wording was incorrect. The question wasn't formulated properly. At that time, I contacted the county counselor and expressed my concerns. Didn't hear back. So on September 2nd, I sent him a memorandum of what we thought the issues were and asked him to let Mr. Emming know what we believe the issues were and to correct the petition. That way it wouldn't be a delay in the process. He could move forward with a correct petition. We couldn't directly contact Mr. Emming because the professional rules of conduct prevent an attorney from contacting an unrepresented party that's adverse to the city's position, but the county counselor is statutorily authorized to approve the correct form of the petition.
We appreciate the effort that has been put forth by Mr. Emming and those who represented the petition. We appreciate and support the right of every individual to participate in this process we call democracy and weigh in. Our concern is that the petition, as it's been structured, is illegal, and it has no the city has no desire to do anything but to be respectful of the process and all of the citizens. And this is the only way we can do it, is to proceed with a legal evaluation of the process.
After we file our petition, we're hoping to get a decision by the court within 20 days on the form of the question, but it will be up to the court to determine what the appropriate timeline will be. But we're hoping to get this resolved rather quickly so we know whether we need to move forward with an election or whether we need to move forward with continuing to pursue the expansion of the Starbond district.
Upon a determination of the court as to whether the petition is valid or whether it's not, we will take appropriate action. At that point, we'll go back to the governing body and make a recommendation and receive direction from them at that point.
It's important to make sure the election is valid because according to the Election Commission in Shawnee County, it'll cost somewhere between $168,000 and $212,000 in order to hold an election, and they'll need between 90 and 120 days notice. So we don't want to hold an election that's later declared invalid and have spent $200,000 of taxpayers' money on an election that is invalidated.